Lyle Rapacki, and this is Arizona Today. Now, this is going to be an interesting Arizona Today because if you're in Minnesota or Georgia, you're wondering, well, what are we doing listening to a senior senator in our legislature who is the chairman, co-chairman of an ad hoc legislative committee dealing with family courts in Arizona. So it sounds like all Arizona, Arizona, Arizona. I think you're going to be surprised. What you're going to learn today through this senator is what took place in a hearing yesterday at the state capitol in Phoenix, 7-hour hearing where parents came forward one after the other, not only giving some complaints, but testimony and evidence as to the misconduct, the mishandling, and even we would go so far as the abuse that they've undergone through the courts, through attorneys, and through what's called forensic investigators. Well, now, what does this still have to do with Georgia, Carolina? We've learned that what's taking place in Arizona is also taking place in 3 to 4 other states, almost duplicate. I'm not going to name those other states just yet. I'm not sure if the senator will, because there's also enough evidence, not opinion, ladies and gentlemen, enough evidence that's been presented that it may really require the U.S. attorney to become involved and to launch a very serious investigation, criminal and otherwise. So I'm not here teasing you, but what you're going to hear from Senator Mark Finchem, who's been a guest multiple times, is really sobering. And what took place yesterday at the all-day hearing at the Senate is very sobering, with people coming forward with their testimony. So Senator Mark Finchem is my guest. He chaired the joint legislative hearing, ad hoc hearing yesterday in Phoenix, and we're going to discuss in basic what took place yesterday and what the accumulation of evidence and testimony. So, Senator, thank you for taking time out. I know you're in between appointments. Senator, could you give a brief overview to everyone? What is, because this committee's still intact, what is this joint legislative ad hoc committee, and what are you as the chairman looking for?
Yeah, thank you, Lyle. I appreciate the opportunity. So the Joint Legislative Ad Hoc Committee to study family court orders has to do with not the regular juvenile court, not criminal court, not civil court, but it's family court, which was stood up by the Arizona court system to handle essentially custody matters where there is a dispute over custody, and it's the typical he said, she said stuff, okay? You have one parent who has a certain amount of acrimony towards the other, and then there is the accusation by one parent that the other is somehow either enmeshed with the child and interfering with the normal progression of a hopefully healthy relationship with the other parent, or you have outright alienation, meaning that that one parent is essentially verbally chastising, assaulting, demeaning, bad-mouthing, whatever term you might want to use, but throwing the other spouse under the bus, the other co-parent, if you will, in the eyes of the child. One of the things that disturbs me deeply is that the court has essentially coerced individuals into participating in family therapy. Okay, wait a minute. While they may be a family forever because they share a child, they're not married. And there's a reason. They don't like each other. I know, big shock. But the court has taken it upon itself to force one spouse to reinforce a relationship with the other. Think about this for a second. You have one spouse who's got a substance abuse problem. It might be drugs, it might be alcohol, it might be sex, it might be, who knows what, it could be a collection of all. But they're living a lifestyle that the other spouse doesn't exactly approve of. Okay. You have a child in the middle of this, by the way, and the court is supposed to be focused on what is in the best interest of the child. It seems to me that the parent who is trying to foster a future adult from a little human has a responsibility to see to it that acceptable social norms are recognized and that that child has an opportunity to experience innocence and an opportunity to organically grow into becoming an adolescent, an adult, young adult. Well, now we've got this School of Social Work out of ASU. And the social worker, Katie Hobbs, also called governor, but I use that term loosely in Arizona, was a part of an organization that includes some of the therapeutic interventionists. These are PhD level psychologists, psychiatrists.
Yeah, psychologists.
I can never keep the two straight. I don't know why they have a separation, because they're these head doctors, these mind doctors. Okay. So the question becomes, why is the court trying to infuse itself into a relationship that has failed, number one, and force parents back together in some level of reunification? I'm sorry to keep using my air quotes here, but all of this is psychobabble DEI BS. You cannot force people to reconcile. That doesn't happen in the real world. Now, it does in some fantasy world that these psychologists live in, but they claim that it's for the good of the child, for the best interest of the child. What we're finding in the testimony is the court does not give one whit about the best interest of the child. In fact, they don't even talk to the child. They disregard what the child has to say. Oh, because the child has a warped sense of reality because of one spouse or or one ex-parent or, okay, stop the craziness for a second. We're assuming, the court is assuming, that children are stupid. The children have no sense of loyalty to their parents. Now, I will absolutely agree that there are parents out there, in fact, I'm the victim of one of them, who will do everything they can to engage in character murder, character assault, whatever you want to call it. But it's the diminishment of the character of a parent in the eyes of the child, whether passively or actively. Now, some people, and I happen to know several of them, don't want to encourage their minor, not yet adult, but no longer a child. They don't want to encourage the lifestyle that the spouse is leading because it includes substance abuse, alcoholism, sexual deviancy. They don't want to endorse that. Yet the therapeutic interventionist forces them to speak up and tell the minor, well, your mom or your dad, that's not necessarily abnormal. It's not necessarily bad. You still need to love them as a person. Okay, well, if you want to compel somebody to endorse that, that's a violation of their First Amendment right. Because not only do you have a right, and this is actually Brush and Nib decision out of Phoenix, Arizona. Not only do you have a First Amendment right to speak, you also have a First Amendment right not to. And because these therapeutic interventionists are awarded a status by the court with no jurisprudence, no legislation authorizing it, they are authorized to be quasi-judicial officers of the court. In other words, fake judges, employees that have, or contractors, if you will, that have a level of quasi-judicial immunity. In other words, you can't touch them for malpractice. You can't touch them for assault on the constitutional rights, not only of the parents, but also the children, also the minors. So the ad hoc committee has been looking at these family orders that are forcing people into a contract against their will. Now, the court will use the fancy term, well, you stipulated to it. Well, wait a minute. You coerced me into signing this because the veiled threat was if I didn't participate, you would take my children. Well, that's not such a veiled threat because the court has actually taken children because some parents have said, oh, hell no, I'm not participating in this. My ex-spouse is a sex abuser, is a deviant, and there's records within the court itself to show that perhaps a child was raped, molested, the spouse might have been assaulted, domestic assault. So you have this situation where the family court, and I use that term lightly, claims that it's issuing orders in support of family, when in reality, this has become a financially motivated grift.
Now, the legislative committee that you're chairing had a 7-hour hearing yesterday with testimony after testimony, and there's a couple of more planned. What I'd like to do now, based on yesterday's presentations, is ask you a couple of good questions, and if you'll give me some really quick answers, I'll go to the next question. Ladies and gentlemen, there's far more that the senator could fill you in on, and we will in the days to come. Correct me, Mark, if I'm mistaken on this. Ladies and gentlemen, I'm also going to be putting out, probably with this segment, this show, the 7-hour testimony, the video of the 7-hour, and believe me, it's sobering. It's extremely sobering. So when I say that the senator could enlarge on this, believe me, that's an understatement. But Senator, if I may, because of time, let me ask you a question. Give me a short answer. Let me go to the next question, because I think even the short answers you're going to be able to provide are startling, sobering, and very revelatory as to something's very wrong in the court system, at least in Arizona. But as we've learned, it's in several other states. Would you agree with that? We've heard that it's in several other states.
Yeah, we had, in the testimony yesterday, we had 5 states represented.
5 states, right. So let me throw up a couple of questions. Give me a couple of quick answers. Ladies and gentlemen, he'll come back. We will cover this more depth. It's daunting. We heard testimony, not just yesterday, but before, and evidence has piled into your office, documents, not just handwritten notes, ladies and gentlemen, that children less than 16 years of age have been removed from the custodial parent and put into re-education camps out of state. And the custodial parent, had no idea where those camps were, where their child was.
Yeah, it's called kidnapping. No, I'm not kidding. It's the forced removal of a child from the state of their residence.
Yeah.
And the separation from a parent. Now, in the interest, this sounds a lot like you're going to have to take this chemotherapy. Now, it might kill you, but it's also going to kill the cancer. It's a toss-up, okay? But the fact of the matter is the court is removing a parent's access to the child and picking a winner or loser. Well, not the court, but the court's assigned judicial officer, therapeutic interventionist, is separating the child from a parent, forcing the child, the minor, to repair a fractured relationship based on nothing more than an order to do so.
Now, the children that have testified claim that they were removed from the custodial parent, and it could be a mom or a dad. Mm-hmm. They were taken to these re-education camps. They did not know where they were. They were put in a van, carried to the re-education camp, kept there without phone, computer, any access to any parent. They did not know where they were. And when they were discharged, released, they were then sent to the non-custodial parent to whom they were now supposed to develop a relationship. Yes?
Yes.
The trauma of these children showed up in your committee, the testimonies.
Yeah. There are kids that aged out. In other words, once they turn 18, they can basically tell the court to bugger off. They're no longer under the jurisdiction of the court. And these are horrific stories.
Yeah. My understanding, I'm sorry, Senator, I'm trying to move along.
No, I get it, but this is an important point. This was put in place by politicians and social workers.
Yes.
These children have been harmed. Now, what's interesting is the code of ethics for the psychologists is do no harm. Yet that's exactly what they're engaged in doing for a profit motive.
Now, one of the children that spoke, I believe was 15, maybe 16 now. She had gone to this re-education camp. She outlined very specifically what had happened to her there and what happened after she returned. Be with a non-custodial parent, which was a threat in the first place. Then it became evident 2 days later she was threatened, and so was her mom, by the courts for being in contempt and moved to be silenced. You're aware of that?
Yeah.
So these children...
That would be the abrogation of her civil rights. Yeah.
But again, we heard this in testimony and in documents, not just people talking out loud.
And this is first person. This is not, I heard somebody that this happened to somebody. I saw this happen to somebody. This happened to me.
And she was very specific every step of the way.
Oh, yeah.
Likewise, you heard testimony from parents who spent anywhere from $100,000 up to $5 million during the course of several years fighting all of this.
Yeah.
Several parents testified about how they attempted to do everything the court wanted and these forensic interventionists to meet all the demands, and it cost them bankruptcy. They've lost their houses, they've lost their income to try to pay all these bills.
Because they love their children.
And some of them, now correct me on this one if I got it wrong, some of them, even doing all of that, still lost their children. The court ordered through the forensic people to swoop in, take the child, and remove the child and put it with a non-custodial parent. And the heretofore custodial parent now had visitation 2 hours a week, maybe 4 hours a week, but with a supervised person in the same room.
Yeah.
And that formerly custodial parent who's lost custody, while they're getting visitation, they have to pay anywhere from, don't quote me the exact amount, but ladies and gentlemen, this is in very much the ballpark, $225 to $325 an hour to visit their child.
Yeah.
And there's no end in sight. When you asked, or a member of the legislature asked, you have this visitation now ongoing, is there an end? They couldn't answer it. There's no answers.
This is obscene in the profit motive that is going on. And all of this, this is a classic criminality hiding behind the argument, well, this is for the good of the child. Time out a second. What's for the good of the child is for the parents to retain the money that belongs to them and not pay it to some forensically informed therapeutic interventionist to the tune of $300, $400, $500 an hour for years every week. It is not hyperbole to say that this is driving families into bankruptcy. And the clown of a governor on the 9th floor in Arizona vetoed a bill, House Bill 2256, yesterday afternoon, after the hearing was concluded, vetoed a bill that would have prohibited the court from ordering families to pay for this without the agreement of a parent. It was that simple. It's like, look, I can't afford this. Now, here's what I find interesting. It's not the job of the court to repair relationships between people. Yet the court has assumed that responsibility way outside of any legislative authority. It claims that, well, we interpret the law that we can do this. Oh, hell no. Absolutely not. You have now put yourself in a place, court, where you do not belong. Now, the appropriate thing to do, if you've got an individual who's a parent who wants to have more parenting time, other than the 50-50 division, okay, bring forward your proof as to why you deserve more. If you're going to claim that the other parent is a substance abuser, fine. The court will order, this is Mark's world, the court will order a drug test. But if we find out that you've made this up, you're going to pay for it, not the one it's been ordered against. That right there, I do believe, and by the way, that test has to be done today. As soon as you leave court, got to do it today. If there is any trace that the person making the accusation is telling the truth, then yes, the court has authority to act. And the court could restrict access to the child for a period of time until the parent can come up with, 16 weeks or 6 weeks of drug-free tests. But the point is, we have people that are using the court system as a weapon. And if you're going to make an accusation that your ex has a substance abuse problem, and you're not willing to pay for a test that shows there don't, then don't come to this court again. At the same time, if there is documented proof, and by the way, we had a number of children and parents testify that even with documented proof of sexual abuse by a parent, by the way, this is across both men and women, sexual abuse of children, the courts still force those children to be in the custody of those parents unsupervised. Now, you want to talk about family court and for the good of the children? Forgive me. What the hell do you think you're doing? This is obscene.
I also want to pick up on what you just shared because, without getting into it, I think unless you have more evidence that you could speak into, my understanding is what was presented initially as evidence, ladies and gentlemen. We're not talking hypotheses or theories. Documents, literal documents were included in many of the testimonies yesterday and then earlier that what Arizona has started, put together here, has now reached into California, Texas, Colorado. And just this morning, I got an email based on the hearing yesterday. Somehow the people in Georgia said, Dr. Lau, can you find out from us or for us if Senator Finchem has more information dealing with Georgia, because Georgia has now a very similar situation to Arizona. So
Florida also, because there's a Florida U.S. attorney that wants to look into this.
I purposely didn't mention that.
Well, I'm telling the Florida U.S. attorney, if you see this broadcast, call me. 520-808-7340.
So, ladies and gentlemen, again, while we're talking here on Arizona Today about an Arizona legislative hearing, you can just hear what the senator said and what I just mentioned. 5 other states, 6 that we're aware of. Now, there could be more, but we're aware of because we've seen the documents. And also yesterday, people from California, Texas, Colorado came and testified.
And Michigan.
I forgot about that. You're right. Michigan also. So, ladies and gentlemen, this is a real serious problem that's in multiple states. In our closing time, one of the things that I think you heard yesterday that was a surprise was the Board of Psychological Examiners for Arizona were talking about how difficult it was to get trained individuals. So they were being a little bit more open to bringing people in. The next generation, I think, is the words that they were using. And yet, we also heard from a person testifying, a mom and a teacher who went to counseling classes. She ended up getting her degree in counseling because she's already gone through all of this dilemma, and she wanted to get in to see if there's something she could do to make a difference. And she was shocked at the lack of proper education in her coursework. Am I speaking correctly?
Yeah, she was rather surprised to see that there was so much emphasis on DEI, diversity, equity, and inclusion, the latest buzzwords for psychobabble. And this is all part of the Marxist dialectic and a construct to disrupt society. Funny how it's all Democrats who are involved in this. This is to alter the world to make it conform to their worldview. All right. You may recall the failed political candidate, Hillary Clinton, said it takes a village to raise a child. No, not really. It takes parents that care about the child. And a family unit, whether the mom and dad are together or not, they're still a family. Let's look at the family unit, and I know people don't think about it this way, but humor me for just a moment. Mom, dad, child. That child's in the center of their lives for the rest of their lives, not just while they're a minor. That is your child. And you have a sacred responsibility to curate, to care for the best interest of the child. And right now, I have not heard a single story where the family court has done anything for the good of the child. This appears to be, with the testimony received from children, from parents, that the court is focused on one thing: a profit motive for the bar and the psychologists. Now, whether there are judges who are receiving a grift under the table, we don't know. And I don't really want to go there at this point. But I will tell you that what we have heard so far, there are three things actually on my mind. One is a criminal referral for certain individuals who appear to be acting without a license, claiming to be mental health care professionals. Two, there appears to be a cozy relationship between lawyers and psychologists, both of whom are focused more on billable hours than they are on the welfare of the child. In fact, you ask the name of the child, and most of the people that are involved in this, they couldn't tell you. Number three, it sure looks like there's an opportunity here for a major class action lawsuit that reaches into the very bowels of government. Now, of course, judges are going to claim that they have judicial immunity. Well, that may be true until we prove that you have abrogated the civil rights, namely the First Amendment, of parents and children under color of authority. Now, you may remember Sheriff Joe Arpaio. I'm sure most of your viewers know who Sheriff Joe is. Federal Superior Court judge, or federal district judge, I don't want to give him any more credit than he's got, Murray Snow, put the Maricopa County Sheriff's Office under federal receivership, federal supervision. Why? Because of the abrogation of the civil rights of the people in custody. At least that was the claim. Wouldn't it be interesting if the federal government stepped in and put the Arizona Family Court under receivership because of bad actions having to do with a Section 1983 civil rights case. Just saying, is that a possibility? I'll be contacting a U.S. attorney about that at some point, but right now we're still in collection mode for testimony, for evidence. And quite frankly, this is, even though this is an Arizona thing, we, to your point, heard some pretty scary testimony from other states, not surprisingly California, where judges really don't give a damn about the law. They just do whatever they want to. Now, here in Arizona, we actually have a statute that says the court has to take into account a plaintiff or a respondent's ability to pay. The reality of what's going on here is that it seems as though the provider for mental health care knows the capacity of the person that they have been told to fix, knows that person's capacity to pay. And once their pocketbook has been drained, once their life savings is gone, once they have to remortgage their house or even claim bankruptcy, and it even reaches into grandparents and other family members, once they've paid to the ultimate price, it's only then that the relationship is severed.
Yeah.
Now, I do believe that a sharp U.S. attorney is going to look at this and say, well, not only do we have a racketeering case, but we also have a class action lawsuit that's a mother of all class action lawsuits, because it reaches not just Arizona, but I'm guessing every state where this DEI psychologist framework has been adopted. And it's like weeds. It is everywhere.
Thank you so much.
In case you can't tell, I'm not a fan.
No, it was extremely sobering 7 hours listening to parents who've lost their children, who've lost their homes, lost their income, they've filed bankruptcy, and the cases are still going on. Likewise, as you said, their child was forcibly removed and placed with the other parent, could be male or female, and it was that other parent that has a history of drugs, alcohol, sex abuse, et cetera, and it didn't seem to matter. The testimonies were daunting, were sobering. Thank you so much. I know we're going to come back and deal with this. You've got 2-3 more hearings coming to get to the bottom of it. I know that when you left yesterday, after 7 hours, you had a stack of 39 or so people ready to testify. And it was just a matter of time. So at the next hearing, that stack will at least start off. Those 39 may get a chance initially, but it seems that every day that goes by, more and more people are coming forward saying, I have documents, I have evidence.
Yeah, my administrative assistant, poor girl, I mean, she is getting a dozen calls a day.
Yeah.
Emails, the emails are stacking up. And by the way, I plan to do something that is rarely done with an ad hoc committee at the state level. I'll be putting out a majority report on what we have heard. The large buckets of evidence will probably address this whole notion of parental alienation. Will address the profit motive that seems to be built into this program. The fact that the court is not abiding by its own rules, that it's apparently just totally disregarded state statute on what they are to do. And then, of course, there's this question of self-dealing. When you have somebody who's appointed as a judicial, you have somebody, in fact, this question came up with the Board of Psychiatric Examiners. So you have a judge who empowers a therapeutic interventionist, and by virtue of doing that, empowers them to make requirements of the parents. They fall under a category called quasi-judicial immunity. So I asked the court folks, the folks who handle judicial complaints, judges that have issues. Do you regulate that? Do you hear complaints about that? Well, no, we don't. We only handle judges. Okay. Then why the hell are you giving them quasi-judicial immunity when they're not accountable to anybody? Because they're not regulated by anybody else except the Board of Psychiatric Examiners, and they don't regulate, they don't control quasi-judicial immunity. Now, that's a creature of common law. It's been accepted for a long time, but it seems to have been stretched and warped a little bit. The history of quasi-judicial immunity is with clerks and with resident officers of the court. For example, not just a clerk, but perhaps a bailiff or a transcriptionist or whoever the person is that takes the dictation. Mm-hmm. Not a mental health care provider. That is a twist of the meaning, and it opens the door to the question of self-dealing. These individuals are telling the court, oh, this therapy is going to have to go on for at least another year. Meanwhile, they're the ones who are capturing the fruit of that labor. And we have judges who, and this baffles me, they take the bait hook, line, and sinker without even a question. Because why? Because the psychological babble person, therapeutic interventionist, forensically informed, provides the court with a report that says this parent has issues. Well, no kidding. They don't like each other. It's not the court's job to fix relationships. Now, if you want to alter behavior, the court already has some tools besides bankrupting a family. One of those is to limit the amount of access that a parent has until they can shape up their act and quit using dope or get some help for their alcoholism or get some help for their sexual addiction, whatever that might be, okay? The court does have the authority to limit contact with the other parent, that parent who is engaged in that behavior. But separating the child completely or here's one that's going to blow your mind. You got a good parent who the TI says, oh, you're alienating the child from the other parent because you don't say anything. Okay. The other parent gets thrown in jail. Wow, there's a self-fulfilling prophecy. But what happens? The court orders DCS to seize the child and put them in foster care. Okay, wait a minute. You have a viable parent that child could already go to. Oh, the TI says that they're not so good because they don't endorse the other parent. They're alienating the other parent. All right, that makes absolutely no sense. But then you add to it, what about an aunt, an uncle, a grandparent? They're a viable substitute parent. Instead, you're going to turn this child over to DCS, Department of Child Services, who, by the way, in Arizona, lost 1,300 kids.
Yeah.
Can't find them.
Yeah.
Even though they're responsible for them. So this is a problem that the social worker, Katie Hobbs, now has propagated for even longer. She could have solved the problem yesterday by just signing the bill, but instead she decided to veto it. But then again, it makes perfect sense since she's one of the people who set up the grift in the first place. She is protecting the status quo. We'll have a press release about that probably later this afternoon. I'll be happy to get it to you. But I assure you, sir, we will be having more hearings, and we are going to educate the community about the abuses of the court, the abuses of these psychobabble idiots who have bought into their own worldview, excluding the best interests of the children.
Well, Senator, thank you. I know you're busy. Ladies and gentlemen, what the senator has been disclosing is just a smitten of what took place yesterday for 7 hours in his legislative hearing. There's two, maybe three more coming, and there's going to be far more revelations. Thank you for tuning in. And I know if you're in another state, initially you go, well, why am I listening to Arizona Today and something with the Arizona legislature? I hope we've answered that. And I think what we're showing you is the very, very tip of the iceberg that other states are involved. And Arizona seems to have begun the process of uncovering this. And this senator has gone ahead and moved along to do just that, uncover it in Arizona, and in the course of the investigation, uncover it in 5 other states. So thank you so much, Senator Finchem. I'm Lyle Rapacki, and that's how I see things from Arizona today.